Welcome to The Explainer. Today, we're diving straight into the mechanics of negligence. We hear that word thrown around all the time, right? But legally, how do you actually prove liability in a courtroom? How do you prove someone failed to meet their responsibilities? We're going to unpack that today, focusing on the most powerful legal shortcuts lawyers use to win their cases. So, I want you to start by asking yourself, how do you prove someone was legally careless? If you're injured because of someone else's actions, it's just not enough to say, hey, they messed up. You actually have to prove they breached a specific duty of care owed to you. And proving what someone should have done in a split second, well, that can turn into a really messy, complicated battle of opinions. But what if there was a way to totally bypass all that subjective arguing? Here's our roadmap for the explainer. We'll hit the reasonably prudent person, define negligence per se, look at the black letter law, dive into a case brief on O'Gwyn versus Bingham, explore the emergency twist, and wrap up with a study guide comparing our legal shortcuts. Let's get into it. Part 1. The reasonably prudent person. Okay, so the absolute baseline of all negligence claims is the reasonably prudent person standard. Basically, it requires people to act as a sensible, ordinary person would under the exact same circumstances. Now, you really have to grasp this rule before you can understand the exception. But here's the glaring problem. Proving what this completely imaginary, subjective person would do is incredibly difficult. I mean, it basically asks a jury to make a giant judgment call based on community expectations. Did they use the right amount of caution? Did they weigh the risks properly? It leaves a ton of room for debate. And that is exactly why lawyers are always hunting for a much firmer alternative. Moving on to Part 2, negligence per se defined. Now, take a look at this black letter law. It defines what we call the supplantation principle. And supplant, that's a fantastic legal word, isn't it? It means to completely override and replace. Under negligence per se, a written, specific, legislative standard completely overrides that messy, common law, reasonable person standard we just talked about. So if a defendant violates a criminal, health, or safety statute, the judge can basically say, look, we aren't going to ask what a reasonable person would do here. The legislature already decided what a reasonable person would do when they wrote this law. Basically, if you broke the law, you breached your duty. End of story. Which brings us to Part 3, black letter law requirements. Now, obviously, you can't just pull any random law out of a hat to prove negligence. A judge is only going to adopt a criminal or regulatory statute to set the standard of care if it passes a super strict two-part test. The crucial thing here is anchoring these two keywords in your mind, type of harm and protected class. This is all about nailing down legislative intent. First up, type of harm. The injury that actually happened must be the exact kind of injury the statute was designed to prevent. Makes sense, right? Second, protected class. The person who got hurt has to be part of the specific group the legislature was actively trying to protect when they passed that law. If you don't have both of these elements, the judge will just throw the statute right out, and you are forced to go all the way back to arguing about that imaginary, reasonably prudent person. Let's see this in action. Part 4. Case brief on O'Gwyn v. Bingham. The facts of this case are just heartbreaking. 2 children were tragically killed when a pit wall collapsed while they were playing inside a county landfill. Now, crucially for our legal analysis here, the children had accessed this landfill through an unlocked gate that was right near their schoolyard. And here is the absolutely critical detail. There were actually specific safety regulations on the books requiring the county landfill to be fenced off and access totally blocked to the public. So this brings us to the core legal battle, the central issue. Under common law, property owners owe almost zero duty to trespassers. Since the kids were technically trespassing on the property, the county's defense was pretty straightforward. We didn't owe them a duty of care. So the question is, does the kids' status as trespassers just completely destroy the claim? Or does that statutory safety regulation, the one requiring a fence, override or supplant those old common law property rules? This brilliantly illustrates how we apply our two-part test to bypass those really strict property status rules. Let's break it down. First, what was the type of harm the regulation actually sought to prevent? Well, it was intended to protect the public from dangerous conditions inside the landfill, things exactly like collapsing pit walls. Okay, check. Second, who is the protected class? The regulation specifically aimed to keep out unauthorized persons. The children wandering in from the neighboring schoolyard fit perfectly into that protected class. And the holding here proves the massive power of this legal shortcut.
The court concluded that the statutory duty established via negligence per se defines the standard of care, completely regardless of the plaintiff's status as trespassers. Those old common law rules bypassed entirely. Negligence per se successfully established both the duty and the breach. The county was legally careless simply because they violated the regulation designed to prevent this exact type of tragedy.
But there's always an exception, right? Part 5, the emergency twist. Look, the law is never perfectly rigid. It genuinely has to account for the chaotic realities of human existence. So let's look at a twist, situations where a statutory violation does not automatically equal liability. Take the case of Totsky versus Ritway bus service. A bus driver fails to stop at a stop sign and causes a collision. Running a stop sign is a really clear violation of a safety statute. A textbook setup for negligence per se, right? But here is the twist. The bus actually skidded through the intersection because it hit a patch of invisible black ice. So the court applied what's known as the emergency doctrine. Basically, a statutory breach is totally excused if the actor is faced with a sudden emergency that they didn't create themselves, and the time to react is just too short for a deliberate, non-negligent response. Because that driver only had, 4 to 5 seconds to react to invisible ice, the statutory breach was completely excused. Let's zoom out a bit. Part 6, comparing the legal shortcuts. So, what happens if you don't have a broken law to point to and you don't have direct evidence of what the defendant did wrong, but you still absolutely know they messed up? Enter Res Ipsa Loquitur. It's Latin for "the thing speaks for itself." This is a legal inference of negligence allowed when direct evidence is just totally unavailable. Think of a really desperate plaintiff. Say a guy sits down in a movie theater and his seat immediately collapses. He obviously doesn't have a video of the maintenance staff poorly assembling that specific chair, but under Res Ipsa Loquitur, he doesn't actually need it. The mere fact that the seat collapsed raises a super strong inference that it was improperly installed or maintained. If negligence per se is the legislative shortcut, Res Ipsa Loquitur is the circumstantial, common-sense shortcut. It applies when this type of incident normally just doesn't occur without negligence, and the defendant had exclusive control over whatever caused the harm. Here is your ultimate comparative study guide on how these two very distinct doctrines help prove a breach of duty. Definitely mentally bookmark this. On the left, negligence per se relies on a legislative statute. Its core requirements are the protected class and type of harm test we just walked through. And its effect is massive. It entirely supplants that old reasonable person standard. Now, over on the right, Res Ipsa Loquitur relies entirely on circumstantial evidence. Its requirements are that the accident ordinarily doesn't happen without negligence, and the defendant was in exclusive control. Its effect is that it creates a strong inference of negligence for the jury to consider, basically saving a plaintiff's case from getting thrown out when they just lack that direct evidence. To sum it all up, this is your complete breach of duty toolkit. Whether you're using the baseline standard of the reasonably prudent person, pointing to a written law for the statutory shortcut of negligence per se, or relying on circumstantial common sense through Res Ipsa Loquitur, your ultimate goal is exactly the same: proving to the court that the required standard of care was breached. I want to leave you with a bit of a provocative thought experiment here. We've talked about how these black-letter rules apply to bus drivers on ice and county landfill managers, but how on earth do they adapt to modern technology? Think about it. If an AI-driven, self-driving car runs a red light and causes a crash, breaking a very clear safety statute, who does the negligence per se standard actually supplant? The reasonably prudent programmer sitting in Silicon Valley? The manufacturer? The person sitting in the passenger seat? As technology evolves, so too will our reliance on these fascinating legal shortcuts. Thanks for joining me on this explainer, and definitely keep questioning the rules behind the rulings.